If you or someone you care about experienced sexual abuse while detained at the Illinois Youth Center, Murphysboro, understanding your legal options can be an important step forward. The Illinois Youth Center, Murphysboro, located in Jackson County, was a state-run juvenile facility managed by the Illinois Department of Juvenile Justice until its closure in 2013. And over the years, deep systemic issues surrounding the safety and treatment of youth placed in this facility have come to light. Across the state of Illinois, nearly 1,000 civil lawsuits have already been filed by former incarcerated individuals alleging rampant, ongoing sexual abuse across multiple state-run juvenile institutions, explicitly naming Murphysboro as one of those centers where harm occurred. These civil filings detail a highly distressing pattern of behavior that allegedly spanned decades, stretching from the mid-1990s through the facility's operations. Impacted individuals report that staff members, including correctional officers, supervisors, and other institutional personnel, abused their extreme authority to commit sexual assault, forced sexual acts, and severe intimidation. The lawsuits focus heavily on the institutional negligence, highlighting how management and state agencies continuously fail to supervise employees, investigate complaints, and stop the abuse from happening. Examining the specific details of the ongoing litigation reveals the profound necessity of demanding accountability from state-operated facilities. Across a broader wave of lawsuits filed against Illinois youth centers, the documented accounts show that the majority of victims were minors between 12 and 17 years old at the time of the abuse, and some as young as 10 years old. For survivors of institutional abuse, filing a civil lawsuit offers an avenue to seek financial compensation for the life-altering impacts of the harm they endured. This compensation can cover expenses such as long-term specialized therapy, medical care, psychological distress, and pain and suffering. A major barrier for many individuals considering legal action is the belief that too much time has passed since the harm occurred. Because the center closed over a decade ago, it is natural to assume that legal windows have closed, but Illinois laws have changed drastically to lift these burdens from survivors. In 2019, the state completely removed the statute of limitations for reporting sex crimes to law enforcement, ensuring reports can be made regardless of when the events took place. And for those looking to file a civil lawsuit, the law provides critical protections for childhood sexual abuse survivors. Under the current Illinois laws, individuals who experience sexual abuse as minors have windows to seek civil action. And furthermore, this rule allows the legal timeline to extend if an impacted individual did not fully comprehend the scope or long-term trauma of the abuse until adulthood. Many individuals who experience childhood abuse do not label it as such until much later. And this means your legal options remain open even if the facility is closed or if the individual offender was never criminally charged or convicted. As you evaluate your options, it's helpful to understand the different types of available resources. Here at Helping Survivors, we do the difficult work of finding and vetting experienced legal counsel on your behalf and can introduce you to law firms who provide free consultations and take these cases on contingency. If your goal is to understand your legal rights and options, please reach out to us today.